256 is a new law that recently passed that's going to affect many, many inmates in California. It is essentially a law that says race was never allowed to play a role in a criminal prosecution, but now we're going to expand the definition of how race may have played a role and how this can be proven and apply it to all cases that have ever been prosecuted in the state of California. So let's go over the different elements of AB 256. The first one is that it says, the law has already said for many years, race, national origin, ethnicity cannot play a role in a prosecution, cannot influence a conviction, cannot influence the sentence, etc. So that has already been the law. However, it does some major things that change how inmates can file petitions or how people previously convicted can file petitions to challenge how race may have played a role. One huge change is it expands the definition of how race may have played a role. It expands the definition of racially inappropriate commentary or statements made by prosecution, by witnesses, by jurors. And I'll read to you exactly what it says about expanding the definition of racially inappropriate content. It says racially discriminatory language means language that to an objective observer explicitly or implicitly appeals to racial bias, including but not limited to racially charged or racially coded language, language that compares the defendant to an animal, or language that references the defendant's physical appearance, culture, ethnicity, or national origin. The statute goes on to say that evidence that particular words or images are used exclusively or disproportionately in cases where the defendant is of a specific race, ethnicity, or national origin is relevant to determining whether language is discriminatory. So, for example, let's say a prosecutor refers to someone who's accused of murder as a monster, and that is allowed under the law. Let's say the prosecutor says, this person is a monster. Well, what if that prosecutor happens to use that term, monster, a lot more for individuals of a certain race than white individuals? That would be a huge problem. So that is one example of how terms that might not be racist in and of themselves can be applied in a disproportionate manner. So that leads to the second element of AB 256, which is so important. You might be asking me, well, how could we prove what the prosecutor does disproportionately? All we know is one case. Well, AB 256 also allows for the request of information from the prosecutor's office, from law enforcement, and the judge has to grant that request and order the release of that information if good cause is shown for why it is appropriate, for why it is needed. So in other words, this law says that you might not have all the information you need within your case, but maybe there are things being applied across the board that are not fair, that are disproportionate. Another great example of this, besides the example of using language like that, calling someone a monster, or describing someone's physical appearance in an inappropriate way, another example might be disproportionate sentences. Let's say there's a prosecutor's office that is sentencing people of a certain race to more time when they commit a robbery than somebody of a different race. That's a problem, and that's something this law is trying to avoid. I want to quote for you the section that talks about that, how good cause is really all that is needed. One has to show good cause, and that material has to be disclosed. It says, upon a showing of good cause, the court shall order the records to be released. So the court has to release these records if good cause is shown for why there's a basis for believing that this is the case. So that's the second main element, this forced disclosure from the prosecution, from law enforcement. That's huge. Another major element of this law, which almost goes without saying, of why it's such a big deal, is that this law is retroactive, and that what that means is that it applies to convictions in the past. There are many new laws. My clients come to me, they say, oh, I heard about this new law, that new law. Does it apply to me? And I often have to say, well, it's a new law, but it's not retroactive, does not apply to past convictions, only future convictions. But this law, AB 256, says that it applies retroactively, whether you were convicted a year ago or 20 years ago or 50 years ago. So anyone where race, ethnicity, or national origin played any role in the conviction or the sentencing, they can come back and try to file one of these petitions. And the last element of this that's very important is that the judge has to order a hearing in Superior Court if there is a prima facie case made, which means if there is kind of a bare bones presentation of evidence that shows that there's a likelihood that race, ethnicity, or national origin played a role. And the law literally says, if a motion is filed in the trial court and the defendant makes a prima facie showing of a violation of subdivision A, the trial court shall hold a hearing. It's not up to the judge. The judge has to do this if a prima facie showing is made. So that is this new law. It is huge. It's going to be phased in over time. So people who have certain serious cases are going to be eligible on January 1st, 2023. It's going to be phased in over time after that. Inmates in prison are higher on the priority list. Somebody who might be out of prison or have a misdemeanor is going to be lower on the priority list. But when the phase-in comes, it's important to file this petition as soon as you can, because the law also says that a motion that is not timely may be deemed waived in the discretion of the court. So you don't want to wait, long time before filing this if there is a basis to do this. Obviously, this is after your type of case would be phased in. So that's the new law, AB 256. It's a big deal. It's going to help a lot of people throughout the prisons of California whose convictions or their sentences were influenced by race in an inappropriate manner. If you have any further questions about this new law or other new laws or criminal appeals in general, I'd be happy to chat with you or have one of the attorneys at the firm speak with you. Thank you. Take care.